And welcome to Justice Served TV. I'm Michel Bryant. Hi, Linda Kenney Baden. A sweet deal for former Trooper Brian Fahey, and we got some New Jersey experts here going to talk about the Aidan Kearney case. Is he going to be in trouble also in New Jersey?
Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
So here we are.
Hello to you in person. I was scared to do anything with the live open anymore.
We don't know what we're doing. We're trying things out. We're trying to tease what we're doing at the top, throw a little open in there, and then we get to the goods. So,
all right, and we have some. Well, you want to start? You want to start with where?
Yeah, we do have. Yeah, I forgot we have that as well. Hold on. Okay, just a couple of rip and read items before we get into the guts of the day. I'll start with my Letitia James note. New York Attorney General has been indicted for bank fraud. But don't you hear that kind of stuff every day, that a state's Attorney General is indicted for bank fraud? So that just came down the pike about.
Rip and read, because until you mentioned it 30 seconds before we got on the air, I didn't know. All right,
it just happened. So your rip and read.
More important than that, I didn't get a chance to put up. We have so many documents on the Aidan Kearney matter, but on the Innocence Project, Robert Roberson, we were going to call him. Normally you'll say this, Robbie Roberson. We were going to just show on Monday night because he was scheduled to be put to death next Friday. Yep. For a shaken baby syndrome death of his child. Well, guess what? The Texas Court of Appeals has granted a stay, and it's a very important grant because it grants and it says that it has to go back to the trial court for relief under a previous habeas petition. What is that habeas petition? That's on the issue of whether shaken baby syndrome is junk science, because last year there was a case decided in the Texas Appellate Court in a different court that said that this case called Roark, R-O-A-R-K, if you want to Google it, that said that it was junk science and it reversed the finding of somebody getting the death penalty on that junk science decision. So this is a very important decision because basically it's telling the court, hey, wait a second, there's another court that says it's junk science. Go do the right thing. Big deal, big day today.
It was very confusing that it hadn't happened before. And even, the governor of Texas, who is usually the last person that can say, throw the switch or not, was not helping. And it was universally accepted by investigators, former DAs, that this was a problem, right? And this, as I understand it, was done. This most recent review was done on the court's own. I want to say sua sponte. That's probably not truly appropriate here, but the court decided to take another look before remanding it to the trial court to act consistent with what the appellate court believes is the right thing.
They said is, we're not gonna accept your new habeas petitions. We're gonna go back and look at the previous one. With the previous one, and now, we're gonna act on that, and we're going to change our minds.
So good news, and I don't know anybody that doesn't believe that this is the right thing. So hopefully it'll play out as it sounds like it's expected to. Okay, so talking about things that might or might not play out as expected, we got a couple of cases we're going to talk about today. First of all, I was up in Killingly, Connecticut for the Sean Paul Reyes matter. This was technically not the Sean Paul Reyes matter. This was actually the Brian Fahey matter. He's the now former Connecticut trooper who was ultimately charged with misconduct. It was kind of a slap on the wrist type charge, but he had to appear in court today looking for a diversion. It's a misdemeanor charge. This guy retired after all of this hubbub. Sean Paul Reyes, as you'll know, independent journalist with Long Island Auditor. He goes to his house in Groton, something rotten in Groton. He goes to his house and he's challenging him to say, look, why are you getting 85 grand a year in overtime? You're a desk jockey. So how does that happen? And let's just say that former Sergeant Fahey didn't like that, comes out of his house with a gun, Sean Paul Reyes is retreating the entire time. The gun is not waved in his face, which the court made a point of today, so that in theory prevented more serious charges. But he did spit on him and spit in his mouth, Fahey to Reyes. I'm disgusting, nasty. So today it was the opportunity for Fahey to show up and say, Judge, I want diversion, which is basically a fancy way of saying, we'll put you on probation for a period of time. Keep your nose clean. All these charges will be dismissed like they never happened. Not exactly what Sean Paul Reyes would have liked. So Sean Paul was there to make a statement, a victim impact statement, as it were. Now, here's what we're going to do. I've prepared that event, including an exclusive interview with Sean Paul after the fact, and that's been posted. Take a look at it when you get a chance. But there was something interesting that happened before we got to that, and I'm gonna play this for you. Are you hearing that?
Yes.
Good morning, Your Honor. Jeffrey Nunn, present with my client.
Let me point out, first of all, subtitling is an inexact science. This is the guy, this is the attorney. You can see Fahey is the guy who's sitting down there furthest from the camera. And that's his attorney introducing himself. That's Jeffrey Ment. The closed captioning said something about taking an oath, or President of the United States, or something. It's an inexact science, but you'll get the gist of it. Again, this was before the hearing actually began.
And there is a camera request.
The state has.
Okay, there's a camera request, so that was us, right?
We were full camera, right?
Yeah, here we go.
Good morning, Your Honor. Jeffrey
I
Nunn,
pronounced the United States. Yeah, he's saying his name. But thanks, closed captioning.
And there is a camera request.
The state has no objection with the following qualification, Judge. I had an opportunity to view online some of the video footage early on that was taken by the same cameraman, which I hope inadvertently showed members of the audience, which would be in violation of camera rules related to a particular case. I understand that has been resolved through judicial and through the marshal's office. With that being said, and assuming that that won't happen again, the state has no objection.
No objection. My understanding is that External Affairs has been in touch with Mr. Bryant, who's known and understands the parameters.
Thank you.
Okay, so Internal Affairs had a conversation with the cameraman, and so everything's fine. I was not arrested. They were actually very nice about it. It was a little bit of a surprise to hear it today on the record, because I went through the whole process ahead of time. And I got the call. And Mike Schneider is the guy who's the court administrator who sets all this stuff up, and I put the request in through him. And he said, hey, you showed somebody in the gallery last time. What happened was, you may recall that Sean Paul Reyes had a cameraman who was also charged, right, with the trespassing and voyeurism. What a joke. And they did drop that felony charge. But he popped up after Sean Paul Reyes, and I was kind of caught by surprise. And so the camera shot was not as tight as I knew it needed to be. They're very weird in Connecticut. You can't show the judge, which is why it's his disembodied voice. So you can't really mic him or show him. You can't show anybody in the gallery. It's only the defendant and the attorney and the prosecutor. And then I had to get approval to show Brian Fahey. I mean, crazy. It's that strict. And obviously they take it very seriously. So that one shot from the last time was just wide enough. There were a couple of folks in the gallery that were seen. I'm sure they didn't give a rip, but the judge looked at our footage and it all kind of
That's what happens when you're full camera. I want to let you know, though, I have been admitted in the past pro hoc chiefs in several cases in Connecticut. So if there was a problem, Michael Bryant,
you could cover for me.
I can cover for you.
Yeah.
My local counsel will come for you again. And before we get to Mary and Janelle, new member, welcome. Everybody smash that subscribe, like, share, notify button. We're at 30, almost at 31,000. We want to go to 40,000.
Yeah, why not?
15 months. Okay.
So that was my tease to when we're done here tonight, you guys get a chance over the next day or so, go take a look at the actual hearing, what unfolded, and what a deal that this Fahey got. It's a joke, but not a surprise. Let's put it that way.
Yeah,
okay.
We would have had to call Mark Venero to represent you, maybe. I don't know.
I know.
and I could attest to your really good character and how the fact that you.
I told the judge after the fact, I was clearing up my stuff, and the courtroom had been cleared, and I said, Judge, I apologize, totally unintentional. And I told him what happened. He said, I'm an officer of the court, so I respect the process. I'm not trying to pull a fast one on you. He was very nice. So
that's nice. That's nice to know. They were very nice. And welcome to Turns Off Fun 911. Okay, thank you very much. All right, so now what we're going to do, New Jersey. I love New Jersey. I'm from New Jersey. I'm a New Jersey girl. You all know that, right? New Jersey right now, but because there's a northeaster coming in, pretty severe one, everyone along the beach areas in New Jersey is prepping for that northeaster, the sandbags, everything. I think somebody referenced it here. But when I see a case from New Jersey, we're going to be on it. We're going to be doing the Canaro case in January. But there's a little case we've been doing in Massachusetts that somehow has popped up in New Jersey. And because I'm a New Jersey doll, and because I know, like every criminal defense lawyer in New Jersey, I have the best guest tonight to waddle us through, and I will say that because we got a lot to talk about, the new case charged against Aidan Kearney by a citizen who wrote out and filed a complaint in Wayne, New Jersey. That used to be where there was a great short store to shop in, even Marcus last call. But you know me, I always mix a little fashion in with our
I get my hair cut in Wayne. Did you know that?
Yes, I did know that.
Did you know that? Yeah. This girl, this woman, 17, 18 years, she's been cutting my hair since I came out here for something. I can't remember what it was. Yeah. Wayne, New Jersey.
No, it's not Bob Bianchi. Bob Bianchi's actually on his rig tonight doing his duties in, I think he's in East Orange on the rig, on the emergency rig.
The EMT stuff, yeah.
It's somebody who I've worked with and who has been, before I bring him in, who's been a certified criminal trial attorney since 2006. Just 250 lawyers in the state of New Jersey that are certified criminal trial attorneys. He is the past president of the Association of Criminal Defense Lawyers of New Jersey. That's a big effing deal, peoples, okay? And has received the Middlesex County Bar Association Criminal Practice Attorney Year Award. He's got numerous honors, numerous distinctions. He's been included in a list of super lawyers from 2005 to 2023. He's also included in Best Lawyers in America since 2012. He's been in Lawyer of the Year since 2013, 16, 18, 20, 23 for criminal defense, white collar crime, and he's been Lawyer of the Year for criminal defense in 2024. He's been in the Best Lawyers in America for civil rights, criminal defense, general practice, and criminal defense white collar. He is the one and the only, and he practices at one of the great law firms associated with the Charles Lindbergh case. Someday we'll talk about that in New Jersey. Wilentz, Goldman, and Spitzer. He used to actually work for me at one time, but then he kind of like his hopscotch.
Yeah, well, it happens.
All right, Darren Gelber. Welcome, Darren, to the show. You're making your first appearance, actually, on Just to Serve TV since we started this adventure as our second, as our avocation, Michel Bryant.
And he was a frequent guest on Law and Crime. So,
right.
Yeah. So
right.
We always appreciated his efforts there. So good to see you again, Darren.
Good to see you, Michael. Thank you, Linda. Happy to be here.
The best to be in. And so
hey, let me ask real quick. What happened in 2013, 2014 when you weren't Lawyer of the Year? You had a little gap there. What happened?
I was on tour with the Rolling Stones.
Okay. All right.
That's a false statement.
I actually know the doctor who goes on tour with the Rolling Stones, Brad Connor. He goes on tour with them all the time, which is kind of an interesting thing. I mean, I'm sure that must be a fun story, but that's for another day, just so you all know. Yes, start me up. Next is like you're starting me up. Okay, so we have this little case in New Jersey now.
Or do we?
Or do we? Yeah, that's going to be the question. All right. So Aidan Kearney, who we know and who broke the Karen Reed case wide open, has been, shall we say, a citizen has filed a complaint. I'm going to ask you first whether a citizen can do that for allegedly cyber harassment. All right. Cyber harassment under the New Jersey Code of Criminal Justice. This has been a crime since, I think, 2014 when it got moved out of the Assembly into the Senate and then adopted. And I want to bring actually the statute up first. And then I'll go back to bring the legislative history because it may be important in this case. So let me see if Michael, do you have the statute or do you
That's
want?
what I have the Senate paperwork. Is that what you're looking for? Do you have
No,
something?
that's the Senate Assembly. I'll bring the statute up first.
Yeah, I have the New York Senate bill. That's what I've got.
Hold on a second. And the complaint first. Let me see. Here we go. Add it to the screen. If I can.
Let me see
Missing.
if
Trying to
Right,
add that.
there
to
you
the
go.
screen. It's going. Is it going? It's going. It may be added to the screen. It's not going. There we go. Missy's to my rescue here. Okay, and then I'm going to answer a lot of your questions after, but let me tell you all know I can't operate the questions and the screen at the same time and talk. It's just one of these little things I'm not that perfect at. Anyhow, this is the revised code in New Jersey. Everything is criminal statutes are under since 1972 under Title 2C. We are pretty modern in New Jersey. We have all of our codes, unlike New York, in one location. And this is 2C colon 33-4.1, crime of cyber harassment. Now, Darren, the crime of cyber harassment is sort of like, I guess, cyber stalking. I use them interchangeably when I tweet about them or X about them. A person commits the crime of cyber harassment if, while making one or more communications in an online capacity via any electronic device or through a social networking site with the purpose to harass the other. With the purpose to harass the other, everyone remember those words. Number one, threatens to inflict injury or physical harm to any person or the property of any person. Number two, knowingly sends, posts, comments, requests, suggests, or proposes any lewd, indecent, or obscene material to or about the person with the intent to emotionally harm a reasonable person or place a reasonable person in fear of physical or emotional harm to his person. And then there's an or. We'll talk about the or later. The complaint that was filed in this matter against Aidan Kearney is by a woman named Donna Bisbal, I believe is how you pronounce her name. Aidan Kearney has several renditions of her name when he was tweeting about her and talking about her and posting an article about her. And we have the actual complaint because Darren got it from our great New Jersey court system. But we're going to show you the one that Aidan Kearney posted because he has actually redacted some personal information like addresses and things like that, which then suggests that he's not trying to harass you. If you're trying to harass you, would redact that stuff. But that's an aside. This is filed in Wayne Township Municipal Court. Tell us what the complaint that is filed by the complainant here, Ms. Bisbal, and what happens in New Jersey. Why is it that a citizen can file a complaint? Does that mean that there is a case that's going to go forward to the grand jury? Does that mean the prosecutor takes it? Just give us the general and then talk about the specifics, if you will.
Sure. So in New Jersey, and I tell this to my clients when I meet them because sometimes they're shocked to learn. If I walk into my local municipal court and I go to the court clerk and I say, Linda Kenney punched me in the face yesterday for no reason, and I want to charge her with simple assault, they will hand me a form and they'll say, write it out. And I will write on a piece of paper, Linda Kenney punched me in the face yesterday for no reason, and I want to charge her with simple assault. I swear that this is true, and I sign my name. And when I hand that into the municipal court clerk, they will draw up a complaint charging Linda Kenney Baden with simple assault, just based on the fact that I'm saying so. And so it's clear to me that the individual who's the complainant here went to Wayne Municipal Court and said, I want to charge Aidan Kearney with, harassing me. Maybe she said cyber harassment, maybe she didn't. And she filled out a form. She filled out an affidavit about what happened and handed it in. And then the municipal court clerk types up a complaint, and the person who wants to file it signs it and hands it back into the court. If a judge or certain non-judge municipal court employees, if they read this and decide, well, this seems like it's enough that somebody should have to face this charge, I'm going to authorize it by making a finding of probable cause, not based on hearing, not based on testimony, not based on cross-examination or anything like that, just based on the written affidavit that was submitted then a complaint like this gets generated. And so this complaint was issued based on the word of the person who filed it. And cyber harassment is what we in New Jersey call an indictable offense, what many people would just think of as a felony. It's a low-level felony, the lowest level we have here in New Jersey, a fourth-degree offense.
Fourth degree, right, which are on low level, right?
Punishable by a maximum sentence of 18 months in jail. But the municipal court will now take this complaint, and because it alleges a felony, they will send this complaint up to the county court and to the county prosecutor's office. And now it's in the hands of the county prosecutor's office. And they will review this complaint. They might reach out to the person who filed it, and they will make a decision. They can dismiss it outright. They can just say there's no crime here. We're dismissing this. They could decide that, listen, maybe there's something here, maybe there's not, but we're not going to keep it as this fourth-degree felony. We're going to downgrade the charge. We're going to reduce the charge to harassment, not cyber harassment, just harassment, which is a much lower level of offense, not a felony, and then send it back to Wayne Municipal Court and say you can duke it out there. That's the second thing they could do. Or the third thing they could do is they could say, wow, we're going to keep this case and we're going to prosecute it. We're going to keep it up at the county level. We're going to present it to a grand jury. And if a grand jury votes an indictment, then the case will proceed at the Superior Court level. So right now, this complaint is in the hands of the county prosecutor's office. As of yesterday, it had not even been assigned to anybody to look at. There's no assigned assistant prosecutor in the court records. So I doubt very much that anybody besides us and besides maybe Aidan Kearney and our listeners have really paid much attention to this complaint as far as the prosecutor's office goes.
Darren, let me ask you, I think there's something on calendar for like November 17th. Is that right, Linda? Is that the date you're aware of?
Assigned for November 17th.
November 17th. So what's the normal time frame for this to go through the machine, Darren?
So when it gets filed at the Superior Court, the court system computer will automatically generate a court date, what they call a pre-indictment conference. And the goal of that is to bring the attorneys together. And I see that Aidan Kearney has an attorney who's entered an appearance, by the way, in this case.
Yes, Mark Betterow. Yep.
Right. And we have the appearance. Let me just tell you. And we also have the computer printouts on this case, by the way. We're not putting the e-courts printouts up online because a lot of them have addresses and all, just so you know. But because Darren and I are both New Jersey attorneys, but Darren did the work on this, giving him credit. He got all this. Mark Betterow has entered an appearance, who also represents Aidan Kearney in Massachusetts. So I'll just remove that from the stage now. Put the complaint back up.
And of course, was on the show last week. That's in our library if you want to check that out.
So this first court appearance is going to be an initial appearance on the summons. Attorneys very often waive that initial appearance. If the attorney files a piece of paper asking the court to waive that first appearance, they will take it off the calendar, and they will then reschedule it for a different court date for this pre-indictment conference.
Now, the complaint as typed up by the municipal court, as whether or not it was written by the complainant herself or assisted through the court, says that Aidan Kearney, with the purpose to harass and mimics the language, and knowingly sends posts, comments, requests, suggests, or proposes any lewd, indecent, or obscene material to or about complainant with the intent to emotionally harm or place her in fear of physical or emotional harm by harassing her for selling T-shirts with a turtle logo and messaging her inbox, and did a live show with her, a live show with thousands of people watching, and posted her picture writing an article calling her a scammer, grifter, and liar, and people watching sending her horrible messages, and announced the town where she lives and posted pictures of her on a live show, and complainant states she now lives in fear. That's the, I guess that's the, shall we say, the specifications. And then I guess there was screenshots of some social media posts by people sending her messages that was attached to the complaint that were not in the court system. They're in the court system, but we don't have access to them. Tell us how that works.
So the the court system has an electronic computer system that generates these complaints. And once you type in the statute, it'll bring up some statutory language, and it may ask the person filling it out to fill in some blanks. But you see the complaint that was issued does track some of the statutory language. But what's interesting to me is that the charge is based under Section A2. That's the charge here. There's A2 of the harassment statute. And when you read Section A2, A2 is really a statute designed to allow prosecution for what many people would call revenge porn, where people are posting lewd, nude, sexually provocative pictures of somebody without their consent. So you see, it talks about knowingly posting, commenting, requesting any lewd, indecent, or obscene material. So I don't even see any language in the complaint that references anything lewd or obscene. So
yeah, nothing's identified, but they just make that phrase incorporated in the complaint because it matches the statute. They say lewd, indecent, or obscene material in or about on or about the complainant. But on its face, to me, this just looks weak. In the absence of very specific detail that I don't see in the complaint.
It does look very, very weak. And so it would not surprise me at all that when somebody from the county prosecutor's office takes a look at this, that either they're going to immediately send it back to municipal court and reduce the charge to just a regular harassment charge, which has some different elements, but it's a much lower level of offense, not a felony, or they might just outright dismiss the case completely, which would be within.
So let me go take that witness first before we go into whether or not this statute would be constitutional against a journalist who's writing about somebody that they believe is, or they're saying is a scammer and grifter. Those were her words that she put in her complaint. In New Jersey, we have legislative history that helps. First, this statute went to the Senate, right, of New Jersey, and we actually have that Senate appropriations bill. And there's nothing in there that would suggest anything that would differentiate this. As a matter of fact, there's a committee amendment on page 2 of this, which I don't think I loaded in down. The committee amendment of the Senate clarifies that in order to commit the crime of cyber harassment, the offender must knowingly send or post lewd, indecent, or obscene material to or about a person with the intent to emotionally harm a reasonable person or place a reasonable person in fear of physical or emotional harm. So there has to be, you have to knowingly do something, and you have to intend to do something that's lewd, obscene, or indecent, according to the Senate history. And then the Assembly in New Jersey takes it, and let me put that up here. This is called legislative history, and if a court's ever looking to see what a statute means and whether or not it would be applicable to a journalist, they would look at the history here. And again, the committee amendments here on page 2 clarified that the harassment must involve the, quote, transmission of lewd, indecent, or obscene material. The act must occur knowingly and with the intent to emotionally harm a reasonable person or place a reasonable person in fear of physical or emotional harm. Now, if you are complaining about somebody who you believe is and I'm putting a civil defamation aside because this is a criminal complaint, who you believe is a grifter or scammer or is using your turtle logo, even though you don't have it trademarked or copyrighted, is using your turtle logo and selling T-shirts, and you're complaining as a journalist and writing articles and calling that person out, how does that fall into anything that the Senate or the Assembly put in as as a court must look to charge a jury, if they get that far, to commit cyber harassment?
I'm not seeing it. And, I've spent a little time before today's show. I'm not going to say I read every exchange between these two people, but I took a look at a lot of them. And quite frankly, I didn't see anything objectionable in terms of a criminal behavior. And I certainly didn't see anything that any judge, jury, or prosecutor is going to say is lewd or obscene.
And Michael, you actually have the article that Dr. Turtleboy Aidan Kearney wrote. Can we just put the first page up?
Let me see if I have
Let me look up
that.
page
This is
one.
from you're talking about the Post, the X Post
No,
that
the
he.
actual article, well, the Post actually references the.
The Post references the article, which is what I have. I do not have the article
Okay.
specifically.
Now, so
You
this
guys
is
have that? You want to see the Post? What's your
no, we
pleasure?
could do the Post because then Darren did read the actual article. I know because I sent it to him.
Okay, hold on. I got it here. Stand by. I put it right here somewhere. Okay, here we go. I think. Oh, we got to get rid of something else before it'll pop on there. Missy, thank you. There we go. Okay, so let me zoom in to touch on this little thing for you here. Okay, so he's talking about what he wrote, the article. 2 weeks ago, I wrote about a New Jersey woman named Donna Bisbal, and we're not sure exactly if that's the spelling or the pronunciation, this is again, Aidan Kearney, who was scamming FKR supporters by selling overpriced merchandise. Let me fix that here. Try that. There we go. And lying about donating the profits to Karen Reed and Turtle Boy's legal defense fund. She threatened to have me charged by the police if I wrote the article. Evidently, the police told her it wasn't a crime because she went and filed her own criminal complaint, which you've now seen, presumably receiving guidance from Boomer Grifter and another person identified, who seems to think I've been charged. I have not. Anyone can go down to the courthouse and file a complaint. Unfortunately, these two geniuses can't read the cyber harassment statute correctly, and Donna wrote one of the most wild centigraphs ever in her complaint. So that tracks with our understanding of the statute, right, Darren?
Right.
It does, although I like the word centigraph.
I do like the centigraph.
Yeah.
Basically, it's a run-on sentence that turns
I like
into a
it.
paragraph. Yeah,
I like
I think he might have copyrighted that. Work on that, Aidan.
And
Yeah.
the article. The article is he wrote the article before this, and this is what I think caused it. He posted a picture of her, and then he had various tweets that I assume were then. I imagine she would have put them in as an affidavit, as exhibits to the affidavit, but we don't know because we haven't seen them because the electronic system from the court does not show them. But I guess anyone can go down and read them if you wanted to go to the courthouse to see the actual affidavit.
So I disagree with Mr. Kearney just on one thing he said, and maybe it was true when he said it, but he has now been charged. So there is a charge out there. There's a charge, there's a complaint. It's based on a citizen filed complaint. It's not a charge that was filed by the police, but it is a charge. It's been docketed in a court, and it's now going through the normal process of being reviewed by the county prosecutor. And maybe it'll get dismissed by them, maybe it won't. But I would say technically it is a charge that's now pending.
Let's talk about that, Darren, because remember the nature of the charge, whether it can ever be proven or not. This is a charge that you have been cyber harassing / stalking somebody with some lewd and obscene materials. There's some stink on that, right? I mean, there's some taint that attaches to a defendant as just because somebody wrote up this complaint.
And so by signing the complaint, she is now exposed potentially to being sued by Aidan Kearney for defamation or libel or both.
Abusive process, I guess, right?
Yeah, and abusive process, sure. So the police have certain immunity from these types of lawsuits when they act in good faith based on probable cause or information supplied by other people. But when you go down to the courthouse yourself, if I went down and I say Linda Kenney punched me in the face for no good reason, and it turns out I can't prove that or I have no evidence of that, and it gets dismissed, I tend to think that Linda, knowing Linda, is going to sue me for,
The ink wouldn't even try.
He's violent and wants to sue you.
Yeah, as you know. Or it was my client, as you know, I would be representing my client, and the ink wouldn't even dry me. I'd be in that courthouse because you and I have worked together on cases. And Darren knows how I could look very sweet, but I'm a bitch. But I could be vicious. I'm just kidding.
Oh, sure. I see you're winking. Yeah.
Anyhow,
so I'll tell you what. If I had my druthers as rather representing her in the criminal matter or representing Aidan Kearney in a civil case. I'll take the civil case right now. Thank you very much. Just based on what we know at this point.
Yeah, they're very interesting. So then we go back, and then Michael, would you bring up the Carroll case? We're not talking about the cyber harassment statute as New Jersey attorneys in a vacuum here, peoples. We're talking about it because there is actually a case. One great thing about New Jersey is that, to give the judges guidance when there is a statute, there's a cases that will be put underneath the statutes that'll say here, for further guidance, Your Honors, look at this case. And
Hey, Missy, could you clear the decks there, and I'll bring that case up?
The one case that comes up is a case, State versus Carroll. For those of you who are lawyers, would like to look it up. It is 456, capital N period, capital J period, super period, 520, comma, and then it is in 2018. I'm not going to give you the Atlantic Digest site, just the New Jersey super.
It is 196A, third 106, just in case you have a different reference volume there.
No, I don't have a different reference point.
You don't
And
have
we
that?
should go, I guess, to page 5 on that.
Okay. Let me scroll for you.
We're scrolling. Michael's scrolling for us, Darren.
Okay.
He's a good scroller.
I can scroll with the best of them. The court won't even get mad at me. Okay, let's see. I think that's page 5. What are we looking for? What am I zeroing in on?
Okay, let me go up to, hold on a second. This has to do with, can you get a little bit bigger there?
I can get bigger. I can get smaller. You name it.
Okay, hold on a second. Let's I go down that one more page, Michael.
Okay.
Okay, here we go. All right. Darren, talk to me about this case, because here, this case, the court clearly said that, hey, you have to have lewd, indecent, or obscene material when you're dealing with charging somebody with a fourth-degree offense for a cyber harassment. Tell us about this case. I'm posting the relevant language right there.
So, in this particular case, there was some language posted online about somebody that I think under any reasonable view, you would say it's pretty coarse, maybe it's a good word, a little harsh, little pointed. How about that? But certainly, even at its worst, I don't think anybody could say that it was lewd or obscene as we commonly understand those terms in the law. And this decision makes it clear that this statute, at least this subsection of the cyber harassment statute, is really addressing obscene sort of pornographic material here. And just because you're calling somebody a name, just because you're maligning them, just because you're speaking of them online in a very unfavorable way, hey, that's part of a free society and a First Amendment. You may not like it, you may find it upsetting, but unless it crosses the line into obscenity, this cyber harassment statute is not going to help you.
Yeah, I mean, it's very clear. Coarse and insulting, suck it up,
Right. As a matter of fact, I think the court even said that some of the language in this Facebook post, which is what it was.
Indisputably coarse and insulting, yeah.
Right, and we could imagine what it was. Maybe it was using some of the words. No, I don't think it was using some of the words from our Mad Libs last night, because that was still a family show.
Of course. For those who missed it, that's out there somewhere too.
That's out there. If you missed our Mad Libs last night on another one of Aidan Kearney's cases, we certainly went out of character, shall we say, from our very important lawyer roles. Every once in a while, you have to have a little bit of, you have to temper the seriousness of these things. So we try to temper it for our audiences here. But Darren, also, she specifically in her pleading mirrors the statute's language about coarse, obscene, and lewd, right? There's a subsection 3 of the statute. There's an or. Let me put the statute back up, everyone. And again, Missy, could you take that off, and then we'll put the statute up? Go, and then I will add this back to the stage. And I want to talk about this disconnect here. 3341, and we've been talking about sections 1 and 2, which is what's in the charge that she charged. There's an or here, and people can see it. Or threatens to commit any crime against a person or person's property. Is that or meant to be or like a standalone or does that section 3 have to go with 1 and 2 about the the lewd, indecent, and obscene material?
No, I think this would allow a prosecution if this were the charge that's not based on lewd or obscene material. For instance, if I post online with a purpose to harass somebody, that I'm going to come over to your house, and burn your house down and kill your dog or something crazy. If I threaten to commit a crime against your person or against your property, and I post that online or through social media with an intent and purpose to harass you, then I think I violated this cyber harassment statute.
Yeah.
So basically, this is the old time Title 33, 2C 33.4, that was with harassment, but what you would do when you didn't have computers and social media. So when this statute first started, that would be the tracking of the old time harassment statute under Section 2C 33-4.
That's right. So that's the lower level offense. That's not a felony. So if I say to you to your face, hey, I'm going to burn your house down and kill your dog, I'm committing, if I do that with a purpose to harass you, I'm committing a petty disorderly person offense of harassment. What this does, if I do the same thing through a social media posting, that has now elevated the seriousness of the crime to this offense, which is a 4th degree low-level felony.
Right. I think under the previous statute, which is plain harassment, that was what we call in New Jersey a disorderly person. Just so you know, we don't have really felonies in New Jersey. We have 4th, 3rd, 2nd, and 1st degree crimes. And that's when our Title 2C changed over. It makes it very easy to track. And below that are disorderly persons, which are like 6 months or less in jail. We would call like a misdemeanor, like if you were in New York City, maybe a misdemeanor type section. But in New Jersey, we make it very, very easy with regard to this. And 4th degree crimes, if you have no prior offenses and haven't been in jail, even if you have, are normally presumptively non-custodial, right, Darren?
Yeah, it's pretty difficult to go to jail on a 4th degree offense.
Right.
You almost have to want to go to jail, like off the judge or something.
But you would end up having that, you got to check the box. Do you have any felony convictions? Which can haunt you in a lot of different parts of normal life. So
yeah. Okay. So let's just I have to give a second a palate cleanser, but we'll go through the next set of questions I have of Darren. Marie Janelle, we showed you new member, tons of fun 9/11. We showed you new member. Beth V, new member. Again, I'm going through all the new members. Oh, this is Deborah Gelsey. Thank you, Deborah.
Thank you, Deb.
Somebody already in the chat has gotten those memberships because they're assigned automatically to people in our chat who are subscribers, which is a benefit if you subscribe. Somebody donates some of the memberships, they go to you only if you are a subscriber, and you can only chat if you are a subscriber too.
Look,
so
I'm peeking over. Peeking over.
Member for 6 months. And Joey Kane is here again. They gifted 1 Justice Serve, and then Joey gifts another Justice Serve, a couple of donuts. Kay Schmidt gifted 5 Justice Serve TV memberships. We also have Darren. This is where you follow him. Sarah Be Creative, a new member. And Verita Dia asked a question. If somebody is on bail in another jurisdiction, will this charge from a citizen that hasn't even been looked at by a prosecutor? And as far as I'm concerned, from what I have seen, nothing that has been represented here satisfies any, and certainly not beyond a reasonable doubt of a conviction. But it does go up to the prosecutor because her affidavit does show probable cause. So will this, in that meantime, before anyone looks at, could his bail be revoked, for instance, in another situation, Darren, because of this?
I guess ultimately it would be up to the judge in Massachusetts, but I have a tough time thinking that any judge is going to place too much stock in this particular complaint. It may be brought to the judge's attention by whoever's supervising Aidan Kearney on behalf of the court. But I just can't believe that any judge would take action regarding somebody's release status based on this complaint.
Okay, so let me give you and Michael the next section here. The next
It's that darn due process there, and it just gets in the way, you know?
the Aidan's a journalist. The courts of Massachusetts has found he's a journalist. Judge Doolin's found he's a journalist. He has a right to write about things that are a matter of public interest, whether it touches upon him privately or not. This statute, if this statute impedes his abilities to be a journalist under the First Amendment, wouldn't it be as applied then unconstitutional if that's the case?
So I am sure that if this case goes anywhere, which is a big assumption, by the way, but if this case proceeds, I am absolutely certain that the prosecution would face significant First Amendment challenges to a prosecution. However, the statute requires a purpose to harass somebody. And so there may be an argument on behalf of the prosecuting authority that takes it outside of the protection of the First Amendment. You know, if a journalist, it's almost like actual malice, you know, in these First Amendment cases, that if a journalist publishes something that turns out to be false and does it with actual malice against somebody, it could be actionable, even though they're a journalist. So the allegation that these statements were made with a purpose to harass might be found to remove this from First Amendment protection, but certainly the First Amendment is going to be a big battleground if this case goes anywhere, which I don't think it will.
Yeah,
And that I think that's appropriate. I mean, being a journalist and exercising your First Amendment rights is not a get out of jail free card for anything you ever write or do. You know, there's got to be some limits, and so this to me seems reasonable in terms of a limit.
But the complaint, you and all three of us agree, as we have seen it, without any bad.
Oh God, no.
Unreasonable. This is in Passaic County, Paterson, New Jersey, where I've tried cases in Paterson, and they've got some big issues. And the Paterson prosecutor, I think, unless the Paterson prosecutor wants to hit with the First Amendment case and all, this would take significant time. But let me just tell you, we had Aidan on our show, as we have had a number of times, and the show, if you want to reference it, was this one. We called it the Aidan interview, no drama-rama, because we like to talk about the law and the facts on JSTV TV, except when we did Mad Libs last night, and we kind of went out of character, as you all know. And Ms. Bisbal was commented on the show. I'm going to put those up there. They are public in the comments section of that show for everyone to see. And here, she said, "Hi, Linda. Don't you think it's best to get both sides of the story?" I agree.
Okay, are you going to hold on, because people can't see that? Are you going to put that up? You want me to put that up?
Yes. Would you put that up then, Michael?
Okay.
I'm sorry.
Yeah, let's make sure that folks can read along with story time. Let's, if we can pull that one down, Missy, give me a chance to find the first of the various emails we have here, or postings, I should say. Let's see. This is yes, I believe this is the one. Here we go. Stand by. There we go. I got you, right? This is the right one? Okay.
You got the right one, because we're going to have 2 pages on this, because you're going to see my final reaction and her final reaction of our discussion when we go through this.
Again, this is the person we believe is the complainant, right?
Right. We believe the complainant. Her indicates she's the complainant. We're going to take her at her word, although I did have, and excuse me if I wanted to go down because I did not put something in. I have an Instagram. Whoa, I'm disappearing.
What are you doing?
No, don't go away. Don't go away. I have an Instagram. I didn't put up because I just Googled her name and it came up Donna Bisbal, and it came up, and I didn't put this up, but because it was a small, and I put up like Aidan Kearney and Instagram 3 months ago. She had a name, Donna Marie Salvato, and she talks about an amazing stadium. And then back at it, I'll be taking orders for T-shirts again, but I don't know what orders these are for. Okay, so I didn't put it up. But so when you say we believe this is the complainant, because she also has under her Instagram Donna Marie Salvato and then parens Donna Bisbal.
And it's spelled the same way, Bisbal, right?
So I just point that out.
Okay.
All right. Besides the story,
just trying to avoid the litigation. That's all.
We really
go ahead.
Well, we were asking Aidan about all sorts of things. And this did come up, okay? And as I said, we entered this case with no opinion. We came out of this case. It's really wrong to indict the innocent and indict a journalist who brought it all to the public, okay? Everyone has a standing invite to the show, okay? All right, and that's because we were talking about something else. We really weren't talking about her on the show. And then you can see she then said, you don't know me, because Aidan had mentioned out her name and that he called me a scammer. And then in caps, you see, very upset. Find out the facts before you allow people to lie on your platform. Have a great day. All right. Then it went on. It went on. And so I could see how maybe the commentary with Aidan and her and text messages, which there are a lot of in that 45-page article that Aidan did on his Turtle Boy show. Could we put up page 2, Missy, of this, where I can put, if you could take that down.
Let's see. Let me pull up. Let me find page 2 for you here. Stand by, because that way I can manipulate it. It's a little easier to take a look at. Okay, Missy, put that one up. I think, I don't know if we can push in on it or not, but there it is.
All right. So I had said to her, you could come on the show. Please, we invite you on the show. And she said, I would love to accept your, after my court is over, I'm handling things the proper way. Have a great day. Okay?
Yeah, that could be sooner than she thinks.
Yeah, and the invitation, she can come on and we'll make room for her on the show almost any day, except a couple guests that may have serious time issues to only go on certain times.
Why do I think that if she is shut down prematurely in her mind, that she ain't going to want to come on and talk about it?
No, I think that's the issue. So you can read. I don't have to go through it. You could, if you want to go back and read Aidan's article on Turtle Boy News, you can read it all because he puts a lot of stuff in there. We don't have what she has put in her affidavit, except that she is charged with this violation of this conduct for a lewd, obscene to purposely harass.
Yeah. It's a huge gaping hole, Darren. I don't see how you get around that in the absence of those very specific allegations.
Yeah. I don't see how you get around the lewd. Darren, you tell me, purpose to harass another. You have to knowingly post the communications, purposely to harass another, send a post that suggests or proposes any lewd, indecent, or obscene material to or about the complainant with the intent to emotionally place her in harm, emotional harm, or physically, or harassing her for selling T-shirts with a turtle logo. I mean, it's very specific. All right, and it goes on. I mean, you can read it. It's there on our show. So, Darren, are we missing anything?
If we are, I don't know what it is. So Aidan Kearney did post some pictures of her that I saw on his website, but it looks to me like those were pictures that were taken from her social media posts.
Yeah, yeah. They were not.
She's fully clothed.
Yes, and they weren't unflattering. They were just her. Yeah. This reminds me a lot, Darren. Let me get your take on this, of the Massachusetts statutes that have been used to create the claims of witness intimidation against Aidan Kearney, where there's this component that your feelings were hurt. Now, in this case, it relates to lewd or obscene material. So that I'll give you a pass on that. But it's the same element. This you hurt my feelings. You said something that hurt my feelings or made me feel like I couldn't testify. And it's this emotional component that really causes some problems in Massachusetts, anyway.
And we do see that here in New Jersey. I mean, we do see our fair share of harassment complaints because somebody called somebody a name or spoke poorly of them on social media, called them a fraud or an idiot or whatever it is. But not every insulting comment, any flippant, rude comment about a person is a crime. And I think, unfortunately, we see people resorting to the courts a little bit more these days than maybe we have in the past when they're upset about the way somebody's talking about them.
We're too soft.
Hi, by the way, I was at Turtle Live. Thank you for covering this. Hi, Aidan. Yes,
hey,
you did not. You did not ask us to cover this. Okay. We did this because I practiced my whole life, mostly in New Jersey, as everyone knows, and Supreme Court Darren knows. Darren is a major New Jersey attorney. I think we have the dibs on New Jersey. We know the law, we know the action, we know how it goes, and we can tell you that just because somebody filed a complaint and the affidavit is the judge in the Muni court, or as I said to somebody today, mini court. And the person I said to happened to be a municipal court judge in a different jurisdiction, so that person got a real kick out of it. It says, okay, well, this satisfies. There could be probable cause because it's been affirmed to. You've sworn on the oath. We're getting rid of it. We're getting rid of it. Up to the prosecutor you go. That does not mean that this is a real case, peoples. All right, and that's what I saw people saying. Well, look at this. It's probable cause. And Darren, weigh in on that.
So it's very, very rare, I'll say, for a no probable cause finding to be made at this level. So I've seen complaints issued when you read the complaint, you scratch your head and say, how's this even a crime? How could anybody think this is a crime? I've seen those complaints. So the fact that it was issued and it bears the typewritten name of the municipal court judge as having found probable cause does not really give me any level of confidence that there has been a thorough independent review of all of the evidence here and a determination made that this is a prosecutable case. I've seen people charged with harassment because they changed the locks based on their advice of an attorney after a domestic violence incident. And when somebody tried to get back in their house, they found the locks were changed. I found a judge found that to be the offense of harassment. That got dismissed like 2 days later. So this happens, unfortunately.
Yeah, it's almost too easy, and it leads to abuse of the process. Even a lowly California attorney like myself, who isn't in bed with the New Jersey attorneys, figuratively or literally, I can see that this is a problem. And once again, I'll take the civil case against her before I would take the criminal case that she's trying to bring.
Yeah, and as I said, if this does go to Wayne, since it's a long way out there, by the way, and the Neiman Marcus isn't there for shopping anywhere, but if it does go to Patterson, I'm going there because, Darren, this is our home court. If no one knows New Jersey like you and I know New Jersey and I wouldn't, if she had come to me, now unless there's something that's as lewd, lascivious, obscene, that's specifically not protected by the First Amendment, and that is specifically meant to cause her physical or emotional harm, as opposed to maybe this could apply to her actions to Aidan. We don't even know that, do we, Darren?
No, we don't. And it wouldn't be the first time that we've seen cross complaints arise in situations like this, where the next thing you know, the other person is filing a complaint saying that you've made an unsworn falsification to authorities, or you've fabricated evidence against me. And now we end up with two cross complaints that really don't belong in any court, but I've seen that happen too.
Well, as we stand right now, I know which side I would like to cross-examine for. I'll let you all figure that out.
Oh boy.
Oh boy.
My guess is there's not a chance in hell that's going to be happening, because this is going to go away. I would predict that prior to the 11/17 hearing, and you can tell me how often this works, Jared, both you guys, is there a determination before it even gets to that very early process that it's basically tossed? It means nothing and they go nowhere.
Yeah, it happens all the time.
Okay.
Once the prosecutor's office assigns somebody to look at this, and they pick it up with the pile of new cases that have just been assigned to them, and they read this, that could be a week, it could be 2 weeks, it could be 3 weeks, but clearly it's not beyond the realm of comprehension that something's going to happen even before the next scheduled court date.
Okay, that's my bet. That's where I'm putting my money.
Yeah, once the prosecutor gets assigned, and maybe now that the prosecutors are seeing that this is now in the public interest, hello, Justice Serve TV, and they'll take a look at it faster than you can say lewd, lascivious, obscene behavior. This is really revenge porn to me. This is what the statute was all based on. Anything that we didn't ask you that you want to tell us about this statute, Darren?
Not about the statute, but this is exactly the reason why felony offenses can't be prosecuted by private people. You may be able to get the ball rolling. You may be able to sign this piece of paper and start a process, but very quickly, very early on, somebody who's a professional prosecutor and knows what the law is and knows what cases can be prosecuted, knows what cases can be proven, they're going to intervene and they'll make a decision about where this case goes next. So that's a very welcome part of our system, that private citizens can't push this too far.
Yeah.
Maybe
it's a
this
very
Yeah.
interesting balance, because you want to give people access to the system, but how far do they get to take it before somebody with a brain says, hold on, I would hate to have that job. You're fielding all of these odd, random complaints that have just been written up by somebody who feels they've been, injured somehow. You've got to have two piles. This is the crap pile, and this is the legitimate pile. And that's your job, to go through those. So God bless the person who has to do that. I get it. You want folks to have access, but they can't abuse it either.
Yeah.
And different counties in New Jersey work a little different. Like, for example, in Middlesex County, there are a team of prosecutors. They're called zone prosecutors. And basically every day they ride around to the different police departments and different courts in the county, and they'll take a look at the newly issued complaints right then and there. And that sometimes they make a decision right there at the municipal court. We're not taking this up at the county. And they'll downgrade it or dismiss it right then and there. Passaic County seems like it may be a little different, and maybe it's a volume issue. These cases apparently get sent up to the county first before anybody looks at it. So at some point, an assistant prosecutor is really going to screen this and decide what to do with it.
Which I've been an assistant prosecutor in Monmouth County, tried that penalty case, tried murder case, ran a trial team. You are up against prosecutors all the. You were a prosecutor actually in the Bronx.
In the Bronx, I was an assistant DA in the Bronx.
Yeah, I remember.
Greatest job ever.
Never forget the stories you told us when you and I first started working together about that. It was just amazing. But that's for another show when we want to have a lighthearted show, because we're not saying this because we have no experience. We're saying this because we have a lot of experience being prosecutors, being attorneys in New Jersey, and knowing sometimes if a case is too hot, though, a prosecutor may want to send to the grand jury so they could say, wasn't mine, I didn't do this. That's the other way. That's the other thing, so that they don't take any responsibility. But I don't see that here. In any event, be prepared. I would imagine, if you're Ms. Bisbal, to open your books on everything that you've sold, everything that you've done with regard to sales, because if this
donating,
because if this does go further right down in cross-examination, that's all fair game, isn't it?
Well, it is. And let's also, I don't know this person, and I am making zero allegations about her. For all I know, she's very reputable, and I have no idea. But by filing this complaint, you have certainly opened yourself up to inquiry. And perhaps some assistant prosecutor is going to ask to see her records and whether any donations were made and whether she has made any misrepresentations. I'm not saying she has, but by filing this complaint, in light of what Aidan Kearney has said about her, perhaps somebody's now going to start to look at the things that she may or may not have done. I don't know.
Yeah. Be careful what you wish for. Yep.
Well, Darren, thank you for getting all the documents from us. As I said, we have a lot more that we didn't show because it has addresses and names on it. We do have the computer sheets, the printout sheets from the court and all. As I said, we'd also used Aidan's complaint because he had redacted names and done the work for us. So it looks, the regular complaint looks a little bit better that we did not show you. And we really appreciate it. I wouldn't be surprised, Darren. If you get called to comment about this another. Now that you are the expert in this cyber
That's right. We have you in the Rolodex. We still have a Rolodex here. Good to see you again, Darren. That's always one of my favorite guests on the good old Law and Crime Network. So appreciate you popping back in.
My favorite lawyer I ever worked with of all time. What are you talking about?
Thanks, guys.
Thanks.
Okay, take care, man. Have a great weekend. See you next time. Well, I think we have our collective money bet on this ain't going nowhere. So,
Well, very interesting. His last comment that
that somebody might see it as an opportunity to maybe discourage folks from bringing these cases, not knowing what it might open up for them.
yeah.
Yeah.
Oh, look at this. Is this a Casey hater? I don't know. Is it true help land the plane for Casey? I don't know. All I know is I did the forensic work, and when I see the forensic work, it's like when I see a bullshit case. Okay, that's what is concerning. If the courts are going to use bullshit, then we've got a problem. I don't care who the client or the person is. Okay, so let's get that out. But
I'm going to put. I think we answered this question. I'm not sure if it was for Deborah. Did we answer this for Deborah?
Yeah.
Okay.
So we did answer that question. So I think we've been through most of our questions. We thank Aidan Kearney for joining us. He wasn't scared to join us, and he didn't know what the heck we were going to say.
Hey, we never know what we're going to say. So
No,
how would he know?
We know because Darren pointed out certain things that are available to both parties, and certain things that the prosecutor can do, and certain things that because the court didn't in Wayne what it meant to what they did, and now what the prosecutor would do. And again, we invite everybody on. We invite Aidan on to talk about it more. We invite Ms. Bisbal on to talk about it. We invite the persons that Aidan referenced to talk about. We invite everyone on. We'll have a show and we'll hear your side of the story, but be prepared to defend your side of the story, especially if you're going to talk about New Jersey law, because that's my bailiwick.
So there. Okay. So I don't think we learned anything that changed our opinion about the sketchy nature of this complaint. And I definitely use quotes there because if anybody can just go down to the cop shop and do a complaint, it's really worth about the paper it's written on. So we will keep on top of this, see where it goes or where it doesn't go. But I fully expect between now and November 17th, it may vaporize. Just maybe.
Now, do you want to talk about your other case where you were in Connecticut? Finish our show?
But I do want people to go check out the actual footage, the footage that I did properly this time. I didn't show the gallery or anything like I did the last time by mistake.
But tell us what happened and why.
Well, we don't. What happened was there's this low-level charge. So and there's no priors for Brian Fahey. Again, he's the guy that stalked. I've used that word. Pursued. I've used that word. When Sean Paul Reyes went to his house to ask questions about the overtime, he comes out on his porch. They have a little face-to-face. He says, leave. As soon as he does, Sean Paul Reyes starts to leave. He goes back in his house. That should have been how it ended. The cop goes back in his house. But no, he gets on the phone. He calls 911. He lies, says that Sean Paul Reyes is going to, he's threatened to kill me. Total lie. No evidence of that anywhere. Then he comes back out of the house with his gun and goes nose to nose with Sean Paul Reyes as I'm sure most folks have seen that video. It's out there as he's backing up down the driveway. It's a very long shared driveway, actually. No signs that say no trespassing. So up to the point he's told, you got to leave my property, he's perfectly legal. And so on this backwards pedaling as he's leaving the property and he's got the trooper, now former trooper, in his face, the guy spits on him and spits in his mouth. I mean, it's nasty. Anyway, so Sean Paul Reyes gets charged with voyeurism, a felony that's been dropped, and then some other lesser misdemeanor charges, which have yet to be resolved. Although today, breaking news, and you'll hear this if you watch this report, the DA has already said they're going to change those charges. They're going to work something out. They're going to reduce the current charges, which are criminal trespass, and I think breach of the peace, which is an odd thing to have when you're on private property. But anyway, so those are in the works. I think the embarrassment level has risen for these folks in Connecticut, and they're going to drop these charges or reduce them to something very simple, where it's like $100 fine or something. That just came out today in this hearing. So take a look at the video.
Keeping the light and shining the light is so important on all sorts of things, and then we try to do it here. But let me talk to you before you go, because I know that you're about to hit that. But tomorrow, don't go away, everybody, because this is really important. This is about National Domestic Violence Month, Awareness Month, okay? Please stay with us right now. Tomorrow at 6 o'clock, we have a very important show on, shining a light again on National Domestic Violence Awareness Month. And we have a very special guest on, Sue Savio, whose sister Kitty was murdered brutally by Drew Peterson, who's still in jail, who's trying to get out of jail again.
Yeah, still denies having done anything. Yeah.
He spent an hour with us. There's a couple of glitches in terms of transmissions. You'll see my generator went out, my generator went on, and Sue had some transmission problems. But this last half of the show, there's no transmission problems, but it doesn't matter. Please, if we've done anything important this week, this is going to be the show that you should watch. 6 o'clock premiere tomorrow. Sue Savio, her sister will always be the victim. She'll always be the victim. Her sister's dead, Kitty. And Drew Peterson, again, as I said, she will tell you about his efforts to try to get out of jail, as she brings up at least 16 items, maybe 17 when we end the show, for you to be aware, for you to look at, that may be an indicator that domestic violence is happening either to you or around you, because the numbers are every 7 minutes somebody is abused. And
243 million a year, which I still think is light. I think there's plenty that aren't being reported. So she is shining a light on it, and she's helping people who don't know how to get out of those situations. So that'll be tomorrow night at 6 o'clock.
It was very difficult for her to go through it again, but she is committed to making sure everyone is aware. She's now teaching about lecturing and trying to go on shows to try to help people. And if you're going to ever love anybody who's been on a show, it's going to be Sue Savio.
Yeah,
So,
she's real, and she's really helping folks. So join us for that. Boy, that's something. We'll see what happens with Aidan Kearney. Join us for the show tomorrow night. And if we don't talk to you between now and then, have a great weekend. Thank you, Linda Kenney Baden.
weekend.
What's that?
We have a couple of things were happening this weekend.
Yeah, we do a couple of things. I think we look at the Mark Sanchez civil suit, which is interesting.
Right.
And we look at the Kohlberger parents who wanted the court to hide forever some of the evidence of those 4 college kids who were so brutally murdered. And the court didn't agree 100% with the parents. So we talk about that. All right, then.
Monday, Donna Adelson gets sentenced. All right. So
yeah, that's right. That's on Monday, right? They moved that up.
They moved it up. In New York City, we're going to have a parade.
Yeah, they're not. They are not. I told you. I come from California. We're like Columbus Day. What the hell? It's not a day off. But New York, it's like, yes, Columbus. We must have a day off. Well, we know in Florida, they don't care. In Florida, they don't care. They're sentencing people on Columbus Day.
Yeah.
So
and there's going to be a Northeaster too. But so everyone's going to stay safe. We'll see you tomorrow night. We'll see you over the weekend, and we'll see you Monday. We're Justice Served TV.
Try to do the right thing.
From the skies.